Welcome to Essential Elements of a Financial Power of Attorney. My name is Darrell Tuttle, elder law and estate planning attorney with offices in Tacoma, Tukwila, and Kirkland, Washington. For the next few minutes, we will go through the essential elements of a power of attorney and give you a list of provisions that your power of attorney should have, and if they don't, I would strongly recommend that you amend or create a new power of attorney that has them. A power of attorney is simply a legal document in which one person grants the authority to another person to make decisions on their behalf. Generally, powers of attorney are divided into two broad categories. The first is called a financial power of attorney. The second is called a healthcare power of attorney. A financial power of attorney is the subject matter of this tutorial. A financial power of attorney does just what you might think. It gives the authority for another person, sometimes called an agent, sometimes called a attorney in fact, to make financial decisions for you in the event that you're unwilling or unable to make those decisions yourself. And you'll see an example from the powers of attorney that we draft for our clients, just Article 2, appointing the attorney in fact. In this case, as example, myself, and then my associate attorney, Katie, as a successor in case I am unable or unwilling to act as the attorney in fact, or agent, sometimes called agent. One issue with powers of attorney is simply that they are increasingly scrutinized by banks and other financial institutions when the agent or the attorney in fact presents it. And a common scenario is a son or a daughter of an elderly senior who no longer is able, maybe they've had a stroke or are incapacitated, and they want the power of attorney to be given to their son so he can do the banking for them. And so the son tools on down to Bank of America, where mom has banked for 50 years, and says, here's a power of attorney, and I want to be added as a signer on the account so I can pay my mom's bills. Banks used to cooperate a little better than they do now. And the lay of the land is simply that, anyone can slide a piece of paper that they downloaded from the internet called a power of attorney and get an incapacitated person to sign it. Because of elder abuse and whatnot, banks are just increasingly difficult to deal with. The teaching point here is that the power of attorney must give very explicit and specific grants of authority. Gone are the days of 1 or 2 page financial powers of attorney that said, hey, anything I can do, I want my son as an attorney in fact to do. Now banks will look at each provision, each grant of authority, to determine whether you have specifically authorized your son or daughter, your attorney in fact, to act on your behalf in a way that the bank can accommodate. So that's why powers of attorney are now becoming 10, 15, 20 pages long. I don't like that either, but that's just reality. There are 2 provisions that, in my opinion, every power of attorney must have, and likely yours does not. And the provisions essentially just give the attorney in fact the ability to make a gift. How hard is that? The second is to create and fund an irrevocable trust. However, over time, estate planning attorneys who really aren't perhaps as sensitive to long-term care planning and benefits planning as they should be, have drafted provisions in which it is prohibited for the attorney in fact to make a gift to him or herself. Now, the reason for that is fraud. So elder abuse and theft of seniors is a problem. However, assuming that you trust your children, it is extremely helpful for your children to sometimes make a transfer to themselves, or more importantly, a transfer to a particular kind of trust that is the bread and butter of Medicaid and VA benefits planning. And that is an irrevocable trust, which we will talk about in a little bit more detail. The point is, go to your power of attorney and pull it out. If it says, or if it does not have a provision that specifically allows gifting get a new power of attorney. If your power of attorney prohibits a gift made that ultimately ends up in the pockets of the attorney-in-fact, you might want to rethink that as well. And I strongly encourage you to have a power of attorney that allows the creation and funding, not of a revocable living trust, but an irrevocable asset protection trust. And so here you go. This are the actual paragraphs that we use in our law firm to meet this need. You probably won't see this in your power of attorney, but your power of attorney should have it. So, Section 406, trust. My attorney-in-fact may create and fund a trust. And we list in little paragraphs, little I, or little 1, 2, and 3 down there, create and fund a self-settled special needs trust. And then the second paragraph, create and fund a qualified income trust. Third, sign all necessary documents to allow me to join any trust qualifying under 1396 D4C. Now, we're not going to go into what a special needs trust is and what a D4B trust is and a D4C trust. That's for a different course. The point being, those are very important, the cornerstone, the bread and butter of Medicaid planning. And without that trust, it's possible that you could have a moment of incapacity and forever shut the door for your assets to be protected to pay for long-term care later. So do yourself a favor. I know this is strongly worded, but I'm here to tell you that paragraph or something similar, your power of attorney must have it, period. Another provision in a power of attorney is the effectiveness provision. And there is a provision in every power of attorney that says this power of attorney becomes effective when ... There are two choices. The first is effective immediately, effective as soon as I sign it. The other is called a springing. A springing power of attorney is extremely common and can be helpful when you're younger, but can be a real problem when you're older. Let me explain it. A springing power of attorney says that the attorney-in-fact does not have authority to do anything until I become incapacitated at some point in the future. And to prove I'm incapacitated, the attorney-in-fact must go around town and get the signatures of two busy physicians that don't cooperate, they write a letter and say that I've had a stroke and am incapacitated. Well, attorneys-in-fact sometimes need to act in an emergency. You've fallen, you've broken a hip, you've had a stroke, you're in the hospital, decisions have to be made, bills have to be paid, they have to be paid now. And it is extremely stressful and expensive and unnecessary for your son or daughter to have to run around town getting physicians to sign off on it. So as a general rule, if you're over the age of 70, and I'm assuming that you have good relationships with your children and you trust them, then that power of attorney must be effective immediately. Do not keep or create a springing power of attorney. And here you go. This is an example of what a effectiveness provision looks like. You'll see that in Section 2.01, the granted authority shall be effective immediately upon signing. Section 2.02, it's durable even if I become incapacitated, and it terminates upon my death or when I revoke it in the event that I'm married if there's a divorce. Now, another teaching point regarding powers of attorney, remember that powers of attorney expire when you die. So, yeah, you, the person granting the power of attorney, have to be alive in order for the power of attorney to be effective. Many folks say, my mom passed away last month, but I have power of attorney to open the checking account. It doesn't work that way. Once you have died, there's ways to avoid probate, but an order from the court called letters testamentary is the way that assets are managed after death. We will talk about ways to make that easier in subsequent tutorials, but for today, the teaching point is, when is your power of attorney effective? And don't forget, it is effective even if you're incapacitated. And third, it terminates upon your death. And your power of attorney should consider issues such as long-term care placement, tax issues, and just family gifting. And long-term care placement, it means the authority of the son or daughter who acts as your attorney in fact, or wife. It's often your wife or your husband, but the attorney in fact has the authority to find long-term care placement for you. It might be home care, it might be assisted living care, and sign the documents, the admission documents, to admit you. That's extremely important. Also, you need to grant the authority for the attorney in fact to deal with tax issues. Call up the IRS and say, hey, look, file an extension on your tax return or file your 1040 for you. And then, of course, we've already mentioned gifting in the capacity of funding trust, but gifting also to children and grandchildren to reduce estate tax liability. I have on the screen an example of what that might look like. This is a provision from our powers of attorney, and it simply states that the attorney in fact may enter into, execute, modify, or amend or negotiate a caregiver agreement for personal services. So home care, come on, that's extremely important. If your financial power of attorney does not have that provision, you need to get a new one. And here you'll see an example of a provision that we use for gifting powers. Our provision granting the authority to the attorney in fact to deal with the Internal Revenue Service on your behalf. This includes a tutorial, a brief overview of some provisions on the attorney in fact or power of attorney document that you must have, in my view, must have. But remember, if you don't grant a specific authority, then it's probably not going to happen. We have a program available to help you have a high-quality power of attorney, the same power of attorney document that we draft for our clients here in our office. We have the ability to do that in all 50 states at an affordable price, and you have the ability to select the options that you want. This tutorial is just to help you get started and orient you to the things that you should be requesting. We have additional information on how to get started. And after this slide, I have placed a series of slides that just show, with no audio, won't need to talk about it, but just examples of those provisions in our powers of attorneys that you should think about, that you should probably have in your powers of attorney. And so you can just get an idea of what the language looks like and some of the specific provisions that are extremely important. As always, if you have any questions, you can contact us through this website or give us a call at 855-797-PLAN.